training in the field of examination of question documents and handwriting and fingerprint examination under the guidance and supervision of late Mr. C.T. Bhange, government consultant from question documents, handwriting, fingerprint expert, and criminologist. Mr. Ulhas Athale started his practice as an assistant examiner of question documents with Mr. C.T. Bhange in 1984. After working for 2 years, he started his independent practice simultaneously. So far, he has examined more than 4,000 cases involving more than 15,000 disputed documents. These cases were referred and are being referred for opinion by various courts, both civil as well as criminal, of states like Maharashtra, Madhya Pradesh, Chhattisgarh, Andhra Pradesh, Karnataka, etc. Cases are being referred from various banks like State Bank of India, Central Bank of India, Bank of Baroda, Bank of Maharashtra, etc. Government departments like Income Tax, State Irrigation Department, Nagpur Municipal Corporation, government undertakings like Western Coalfields, Power Grid Corporations, etc. He has examined signatures and writing in different Indian scripts like Devanagari, Telugu, Tamil, Gujarati, and Urdu as well. He has appeared as an expert witness in various courts of different states and in departmental inquiries. He has in his possession ultraviolet rays sources, various types of magnifiers, and measuring instruments among other scientific instruments required for document examinations. He maintains a vast updated library with his latest books pertaining to his field. We are honored to have him as a resource person today. I now request Honorable Ulhas Athale sir to take over, address the participants. Thank you.
Just a minute, sir. Before start of your lecture, I would like to give certain instructions to participants. That few participants, in spite of we have already won or notification given in that circulation on WhatsApp, that they should mention their names. Few participants have not mentioned their name, just initials were mentioned. I request all of them to mention their name, otherwise they will be put into waiting room and they will not be able to hear the lecture. So also, as regards queries, we will open chat box for queries for last 10 minutes, and no personal queries should be asked. Only queries relating to law points with regard to the topic concern, they are allowed. And one more thing, all participants are requested to stop their videos. Only the video of resource person will be played, all other videos will be stopped, and all participants are requested to mute themselves. Thank you. Sir, I request you to start with your lectures.
Yes, thank you, Advocate Salgar, for the nice introduction. Am I audible to everybody? Hello?
Yes, sir, you are audible.
Right. Thank you very much for those kind words. Actually, it gives me a great pleasure to share whatever little knowledge I possess with advocates and judges and whatever, all the person concerned. आणि दुसरी एक गोष्ट मला सांगावीशी वाटते की जेव्हा मी विटनेस बॉक्समध्ये असतो, क्रॉस एक्झामिनेशन सुरू असते, तेव्हा मी व्हॉलंटरीली काही सांगायला गेलो, ॲज यू नो, विथ प्रोफेशनल कन्स्ट्रेंट्स, एव्हरीबडी ऑर द क्रॉस एक्झामिनर सेज नको, तुम्ही जेवढं विचारलंय तेवढंच बोला. बट when the same fraternity tells me that you can talk whatever you want, that gives me an opportunity to talk to you. Basically, I would like to start with a few of the citations which are helpful. This is the first citation which I would like to introduce to our participants. AIR 1980 Supreme Court 531, Murarilal versus State of Madhya Pradesh. You are all seeing the slides over there. Last, I won't read the whole complete text of this head note. I will only read the last line. His opinion has to be tested by the acceptability of the reasons given by him, that is, expert. With the cross-examination, what I have observed or experienced, that the cross-examination is being conducted not on the reasons, but sort of general cross-examination, which has nothing to do with our expert opinion. So that's why while cross-examining the expert, it is important to cross-examine the handwriting or any expert on the reasons given by him. As you are aware, that opinion without reasons is not admissible. The second citation is Lalit Popri versus Canara Bank and others. Here it also their lordships have clearly stated that it is for the court to decide whether the evidence of expert needs corroboration or not. Corroboration of evidence of expert is not always necessary. Now let us come to the another point regarding the expert opinion, that is AI 2015 Guwahati. It says the scientific, the opinion of expert available on record, judge drawing contrary opinion on the basis of visual comparison and regarding disregarding expert opinion not proper. It is for the court to decide whether the opinion is correct or not, and the court has to give the valid reasons for accepting or not accepting the opinion of the handwriting expert. Am I audible to everybody?
Yes, sir, you are audible to.
Yes, sir, you are audible.
Okay, right. Thank you.
Yeah.
Another judgment which dates back in 1952, that is regarding the typewriting. In that case, their lordships in the Supreme Court had stated that the expert opinion on typewriting is not admissible because it does not fall within the ambit of Section 41 Evidence Act. The brief facts were like this, that Mr. Nargunkar was excise commissioner in Nagpur. During his tenure as commissioner, there were certain irregularities in some of the affairs. And to cover up those irregularities, he had prepared one letter which was dated 20th November 1946. During the investigation, it was found out that the typewriter on which the letter was typed, that was purchased in the office in December 1946, 30th December 1946. So there was no question of this letter being in existence in November 1946. During the trial, this letter was placed on record. Mr. Nargunkar was convicted by the JMFC Nagpur. The conviction was also upheld by the Sessions Court as well as by the High Court. But during the arguments before the lordships in the Supreme Court, the point was argued that there is no mention of the word typewriting. Cannot be accepted, and the conviction based on unadmissible evidence is not proper, and hence the conviction was set aside. Then we had to wait till 1990 for this judgment. In this case, the facts were like this: one live hand grenade was sent to one of the person. While opening the parcel, the hand grenade exploded and the person died on the spot. During the investigation, they found out that the address of the deceased was typed on a typewriter on a chit, and that chit was pasted on the parcel. And the parcel, when exploded, the chit also got torn. Somehow they got managed to restore the chit. The chit was sent to the handwriting expert, and during the investigation, they had arrested this S.J. Chowdhury. He confessed that he had got the letter typed by in one of the typing institutes in Delhi. So 13 to 14 typewriter samples were sent to the handwriting expert, and he gave the opinion that one of the typewriters was used to type the chit. The matter came up for evidence before the sessions court, and the handwriting expert was cited as one of the prosecution witness. But again, defense took the objection that in view of the Nargunkar judgment, the opinion of handwriting expert is not admissible and he cannot be examined as a prosecution witness. The sessions court accepted the contention of the accused and his evidence was not recorded. As against this, the CBI moved the High Court. High Court also upheld the view of the Sessions Court. Ultimately, the CBI moved the Supreme Court, and in this particular judgment, their lordships referred this matter to be decided by the larger bench. And in 1996, their lordships held that the opinion of handwriting, opinion of expert on typewriting is admissible because it is a science, and therefore the typewriting and identifying a particular typewriter is based on the scientific study of typewriting. And the last important point is, besides the typewriting has to be construed so as to comprehend the typewriting, as well having regard to the fact that the typewriter was not invented when the Evidence Act was enacted. That was, I'm talking about 1876. And now because of this judgment, the opinion of handwriting expert is also admissible under Section 45 of Evidence Act. Now let us come to the recent developments or the recent problems which we are facing regarding the age of writing or age of ink. Personally, and whatever the books I have read, there is no scientific method by which we can determine the age of writing in terms of days, months, or years, or even approximation of age of writing cannot be scientifically proven before the court of law. And as such, their lordship in Hyderabad High Court or Andhra Pradesh High Court, they have referred saying that this application cannot be allowed. Now, what is document examination? Well, this is what the document examination is about. Forensic document examination is study of physical evidence, and physical evidence cannot lie. Only its interpretation can err. Only the failure to find it or to hear its true testimony can deprive of its value. Whatever the signs of forgeries are there, whatever the genuineness of documents are there, that is already on the record or that is already on the document. If the person concerned or the expert fails to find it, then that is the fault of that particular person or the expert. It doesn't take out or doesn't minimize the value of document examination. Many times a question is asked whether the handwriting identification is science or art. when I say science, the next question is fire. Is it correct that you are not a science graduate but a commerce graduate? Basically speaking, science, handwriting science is not as what we call a pure science like physics, chemistry, mathematics. And again, the question is asked, if you say it is a science, then what is science? Well, according to me, the science is that subject which is based on certain universally accepted principles, be it physics, chemistry, mathematics, biology, and so on and so forth. Similarly, handwriting identification is also based on the scientific principles. What are those principles? We'll discuss later. But the second important question or important point is that also requires the skill. Whether there is a similarity in the formation of letters, whether the letters or the two words are similar or not, you definitely require a skill or art for that matter. Because without distinguishing or identifying the similarities or the differences, we cannot give any opinion whether the signature is genuine or not. As I said, this is what we call the aptitude, skill, or art to determine the similarities or the differences in the letter formations. So, according to me, it is the combination of both science and art. Now, when we say it is a science, I say it is based on certain universally accepted principles. Then the next question comes, what are those principles on which identification of handwriting is based? I think all of us know one of the basic principle, that is, a person cannot write or sign exactly alike or identical. There has to be some variation between the signatures when we put the two signatures at the same time or when we put the signatures at different times. Because our hand is not a machine or rubber stamp to produce the signatures exactly as they are. It is not a facsimile signature as we call it. And handwriting is a product of muscular coordination and mental reflexes. These two taken together, they cannot be repeated exactly in the similar way at any point of time. Another principle of handwriting identification is a person cannot write better than his normal skill. कुठलीही व्यक्ती स्वतःच्या सामान्य अक्षरापेक्षा चांगलं अक्षर काढू शकत नाही. Requires a little bit description on this. The handwriting of a person keeps on changing till certain age, or by the what I call by the time we complete our teenage or by the time we complete our graduation. The handwriting keeps on changing during this period. For example, the signature or the handwriting of a child who at the age of 5 will be different than what his handwriting will be at the age of 10. And there is a possibility that the writing may further change by the end of more than 5 years, by say about 15 years. As per the authorities, the handwriting keeps on changing or it goes on improving or deteriorating by the time we complete our teenage or by the complete of graduation. And once the handwriting is settled into good, bad, poor, then it will not change unless the writing hand of a person is affected by some nervous disorder or because of some physical disability or muscular disability. And in case the handwriting changes or goes on changes because of age, that will be for bad. That is, the handwriting of the person will deteriorate with advancement of age, but it will never improve. According to the authorities, if the specimen if the disputed signature is of a very good quality or a good writing, and if the admitted writing or the comparative signature or writing is of a poor quality, one reason is alone for us to say that the disputed signature is not written by the person who has written the admitted or comparative writing. These are the two principles on which the whole handwriting science is based. These are the 4 or 5 points on which the document is challenged in court of law. That is denial of signature or thumb impression, denial of authorship or the text of the body writing, alteration in the document, interpolation, and recently what we have observed or I have observed, that is regarding age of writing. This is more particularly important or the bank in cases under 138 of Negotiable Instrument Act. People usually say that I had given him the blank check signed in say about 2015, and now he has taken advantage of that blank check and has put the today's date, that is 2018 or 2019. But as I've already stated, that the age of writing cannot be scientifically determined, and usually this question cannot be answered in a positive way, that it is written 3 years back or 2 years back. These are the different methods by which we can examine the document. Examination with reflected light or the reflected light examination is the most common method by which we examine the document. That is, the light is reflected on the document and we are help of magnifying lenses. The transmitted light is, the light is passed parallel, beg your pardon, light is passed through the document. That is, source of light is kept below the document or the paper and the light is on. The light passes through the document or the paper. If there is any disturbance to the surface of the paper or the thickness of the paper gets disturbed, that is reflected in the transmitted light examination. Side light examination is the light is passed parallel to the surface of the paper, and again if there is any disturbance, unnaturalness in the paper, we are able to locate it and we are able to give certain opinion. Ultraviolet rays examination helps us in examining the different kinds of inks. Though the ink look may similar to the naked eyes, but the chemical composition is different and they fluoresce differently under ultraviolet rays. Examination with filters, we have again a wrong notion that whenever the signature is to be put on the revenue stamp, or I'll be more specific, the signature has always to be on the revenue stamp. There is no rule or law which says that the signature has to be on the revenue stamp. Because of ignorance, because of wrong notions, signatures or thumb impressions are put on the revenue stamp, and many times it goes difficult for us to examine the thumb impressions particularly which are on the revenue stamp. That time we use filters. Filters is nothing but a transparent red gelatin paper, or if you use red glass while taking the photographs, the red color of the revenue stamp gets completely eliminated, and whatever the signature, writing, thumb impression is there on the revenue stamp, it becomes very clear. I'll show you those examples with the help of slides later. Infrared rays examination is also the same thing, same as ultraviolet rays examination. Video spectral comparator, VSC as it is technically known as, this is a gift of science to the mankind or to our field. Whatever the methods which I have described earlier, They can be conducted with the help of this machine or this instrument, that is video spectral comparator. Of course, the cost is so prohibitive that a person like me cannot afford to buy, because it costs round about 30 to 35 lakhs. And this is available only in the government forensic laboratories, and they are taking full advantage, or they are making full use of such instrument. There is also known as ESDA, electrostatic detection apparatus. Many times the indentations they appear on the document, and in, that can be deciphered, or that can be looked into by using this instrument. This is most important aspect of our procedure or our opinion. Process of comparison of handwriting oblique signature. Many a time a question is asked in the cross-examination that you have not mentioned the method by which you have come to a conclusion or by which you have given the opinion. Well, there is only one method of comparison of signatures or the handwriting. Here I would like to make it very clear that examining comparison of signature and examination of documents, these are two totally different aspects. Many times the attempt is made in the cross-examination by putting these two questions and mixing up of these two questions. It is not necessary that we should examine the document by all the methods which I have described earlier. It all depends for what purpose the document is referred to the expert. If the question is asked whether the writing is made by the particular person or not, then our approach is different. When the question is asked whether there is any alteration in the document, or if the question is asked whether the inks used for the writing and the signature is same or not. So depending on the questions which are posed to us, we examine the signatures, I beg your pardon, we examine the documents. And while making comparison of signature or handwriting, there is only one method which I'm enumerating now, and that is popularly known as comparison method. First, we examine and compare the comparative signatures and the handwriting. As I already stated earlier, that whenever you put your two signatures at the same time, or when you make signatures on different occasions at different times, there is bound to be certain natural variations in the writing of an individual. And by examining and comparing these signatures and the writings, we determine the range of natural variation of any individual. Then the next step is we identify the individual characteristics, that how this particular person writes the letter A, writes letter Z, X, so on and so forth, or अ कसा लिहितो किंवा ब कसा लिहितो, र लिहिण्याची पद्धत कशी आहे, या प्रकारे आम्ही त्याचा डिटेल अभ्यास करून त्याच्या लकबीची आम्ही माहिती करून घेतो, and we try to find out what we call the individual handwriting characteristic. Then we compare and examine the disputed writing or signature by themselves, whether they show the signs of simulation, whether there is any unnaturalness in the writing or the signature. Then we compare with the comparative signature. The disputed writing is compared with the comparative signatures or the writings. Then we try to find out whether they show similarities or the differences. That is, the disputed writing and the comparative writings or the signatures, they show similarities or differences. By comparing, by following these 3-4 steps earlier. Then important point is determine the reasons for the similarities or the differences. The similarities can be on two counts. The first, that the disputed and the comparative writings are written by the same person. That's why the similarities are there. The similarities can also be there in the signature because somebody has tried to copy the disputed signature. नकल करण्याचा प्रयत्न जेव्हा करतो, when we try to copy the signature, there is possibility there could be some superficial similarities. In the same fashion, there could be differences. One, the signature and the writings are written by two different individuals, or the differences could be because of a deliberate attempt of the genuine writer to introduce certain differences. जेव्हा एखाद्या मनुष्याला पुढे जाऊन सही नाकारायची असेल किंवा लिखाण नाकारायचं असेल, तो जाणून बुजून वेगळ्या पद्धतीने लिहितो. And that's why there could be differences between the disputed and the admitted or comparative writing. And these differences, what we call, is because of the disguise. Because person deliberately makes a deliberate attempt to introduce such differences or the variations. Once we determine the reasons or the reasons for the similarities or the differences, then we give our final opinion whether the signature or the writing is written by the same person or not. Now let us come to the different kinds of forgeries which we come across. The first is simulated or copied forgeries. As the name suggests, I have a signature before me, or I know that how particular person signs. I make a deliberate attempt to put his signature in a similar way, what we call the simulated or copied forgeries. In this, what happens? The attention of the forger gets diverted into two things. And as everybody of us know, you cannot concentrate on two things simultaneously equally well. The first attempt is, or the first point is, he tries to look to the similar model signature, and his second attempt or the second attention is, or second concern is, whether the signature he is trying to copy or forge that is coming up to the model signature or not. Another type of forgery is traced forgeries, ज्याला आपल्या लोकल लँग्वेज मध्ये किंवा कलोक्वियल लँग्वेज मध्ये टोपो मारणं म्हणतात. ग्लास खाली एक सिग्नेचर ठेवायची, जेन्युइन सिग्नेचर, ग्लास वरती एक पेपर ठेवून त्याच्यावरून कॉपी करण्याचा प्रयत्न करायचा, किंवा by drawing the carbon outlines people try to forge the signature. I will explain all these with slides later on. The third is forgery without any attempted simulation. मला समोरची व्यक्ती कशी प्रकारची सही करते मला माहिती नाही, किंवा त्या फोर्जरला माहित नसतं. He tries to copy the signature in his own free manner as if he is writing the signature, or he is real authority or the author of the signature. In this case, you won't find the signs of simulated forgeries or the trace forgery. They are well copied or well written signatures. The fourth is forgery by way of stamp lifting. In earlier discussion, I said we have a wrong notion, आपल्याकडे एक चुकीची कल्पना आहे की सिग्नेचर म्हणजे रेव्हेन्यू स्टॅम्प लावल्यानंतर सिग्नेचर रेव्हेन्यू स्टॅम्प वरच केली पाहिजे. Because of this ignorance, people put the signatures either on one or two revenue stamps. In such type of forgery, the revenue stamp containing the genuine signature is lifted from one document and is affixed to another document. Thereby what happens? The signature made on one document is transferred to another document. The person who sees the signature, he says signature looks like mine, माझ्यासारखी सही आहे, पण मी असलं कुठल्याही कागदावरची सही केलेली नाही. And that's why he denies the signature, that I have not put the signature or the signature is not mine. However, we can identify such type of forgery, and I'll explain to you with the help of slides once this discussion is over. Then the forgery over genuine signature. There are certain, what should I say, habits, particularly in when the terms and relations are good with friends, partners, and everybody. A person, by in genuine faith or genuinely believing that person will not do anything wrong with me, a person puts his signature on a blank paper, and that he gives it to his friend, partner, business associates, and so on and so forth. So long as the relations are good, everything is fair. But when the relations are strained, everybody tries to take the advantage or disadvantage of such kind of papers. And the writing or the text is written, either handwritten or typewritten, on the blank paper on which there is signature is already in existence. If it is a handwritten document, I tell you, in 99.9% of the cases, we can identify whether the signature was made on a blank paper or not, because there are various factors by which we can identify the forgery over genuine signature. And this is again case, new technique as the science has developed in every field. So the technique of forgery has also new methods, innovative methods by the forgers, where the signatures are transplanted mechanically, either by way of copy paste, scan, Xerox, and so on and so forth. However, there is a always difference between handwritten signature and mechanical reproduced signature, either way of scanning or by Xerox or copy paste. The features of writing the signature or putting the signature manually will never be seen, I repeat, will never be seen in any signature which is transferred mechanically by any process. Well, now we are coming to the actual forgery cases. If you are seeing the signature on the top, which is marked as D1, that is the disputed signature, and the signature at the bottom, S1, that is the standard or specimen signature. Now here comes your observation power, or if you remember the slide which I had told you first regarding examination of document. It is a study of physical evidence, and physical evidence cannot lie. Only its interpretation can err, or failure to find out its true value can deprive of its value. आता फॉर एक्झाम्पल हा जो लेटर फॉर्मेशन आहे आपल्याला, and if you compare with these bottom formation, you will be able to see the difference very clearly in the writing process. Here what we call the writing process is more important than anything else. In the bottom signature, the person has written the signature in normal way, without any hesitation or without thinking. On the contrary, in the top signature D1, here you will find the signature is written instead of, I beg your pardon, it is drawn instead of written. What we call it is a drawing movement, because the person had made an attempt to copy the signature as marked as S1. And what we call the defective line quality, unnatural pen lifts, these are seen in the disputed signature signature D1. According to the authorities, mere presence of these signs is enough to declare the disputed signature as forged because they show what we call the inherent signs of forgery. Now let us come to another slide. Here this was a document which was running in 7 or 8 pages. Each signature, if you see, you will see it shows the defective line quality as we had seen the earlier two signatures, earlier disputed signature. Further, if you observe very closely and carefully and minutely, you will find that these two signatures, they are almost identical or they are very much similar to each other, which is contrary to the basic principle that a person cannot write two signatures exactly alike. I'll give you the third slide in which these two signatures are placed one over the other. And here you will find both these signatures, they superimpose over each other completely with presence of signs of forgery in the signature. This means these are traced forgeries. In such cases, we even don't require the admitted signatures at all for comparison. By mere presence of inherent signs of forgeries, as well as the superimposition of these two signatures, that is more than enough for any expert to say that these two signatures are forged signatures without comparison with the admitted signatures. Now I'll show you the third slide. This was a case referred and the disputed admitted signature as S5. This is a photocopy of a document, and this photocopy was admitted by both the plaintiff as well as the defendant, saying yes, this document was executed between the plaintiff and the defendant. So the certified photocopy of this document was filed in the court, and this particular signature was sent to me as admitted signature. Mind well, this is a photocopy of the document and not the original document. As you know, the photocopy, it is a mechanical reproduction. The signature is not put manually here. It is mechanical reproduction. But here, the next slide I am showing you is the back side of the signature, which is marked as S5, which we saw earlier. And here you will find, if you are able to see these points, these are what we call indentations. These indentations show that this signature was rewritten with some object. Why this signature is important, I will show you with the next slide. This is the disputed signature. If you observe this signature very carefully, you will find here the inherent signs of forgery. Particularly, look at this point. The pen is lifted over here, and after lifting the pen, it is moved. Same case is here. Here, what we call it is suspicious retouching. So, in all, it goes to say this signature is a forged signature. I went a step ahead and I say that disputed signature D1 is traced from the signature which is marked as S5, that is the photocopy. Again, you observe these two signatures very minutely and carefully, you will find that these two signatures, they show suspicious close similarity between them. The next slide you will see that the signature marked D1 and S5, they are found to be totally superimposing over each other. That means the signature marked S5 was used as model to forge the signature marked as D1. And fortunately for me, or for the person who had applied for expert opinion, who has disputed his signature, the S5 was also sent to me for comparison, and I could give a positive opinion that the signature mark D1 is traced forgery, forged from the signature mark S5. And I was told that once my opinion went to the court, the plaintiff never contested the case again, and the suit was dismissed ex parte. Now I'll show you the difference between the mechanical signature and the manual signature. The signature marked S4 is a signature put manually on a document. This is the certified photocopy of the sale deed. Certified photocopy of the sale deed, as you know, it is a printout of the scanned copies which are in the office of the sub-registrar. Now, please observe the periphery or the strokes of the signature. Here at the periphery or at the edges of the stroke, you will find some dots all along the signature, which is not, I'll go back to the previous slide. Here, this is a signature which is put manually with the writing instrument. Look at the edges of these letters or the signature. It is a clear cut and fine edge or the strokes. Here you are able to distinguish. This is the disputed signature. Now I'm going to show you third signature, that is S1. This is again the admitted signature on a sale deed. Again, this is a certified photocopy of the document. That's why you will see that this is a zigzag formation. This is because the printout. Now here I am showing the S1 and D1, one below the other. In the third slide, you will find that D1 and S1, they are superimposing over each other completely from beginning to end. So this is the transfer of the photocopy or the mechanical transfer of the genuine signature from one document to another document. This is the forgery which I was talking about regarding the stamp lifting. People have, even now, this is case of course very old, which I done in 83, 84, something like that. Here is a case wherein a genuine signature is appearing on two revenue stamps. The two revenue stamps, they were lifted from one document and affixed to another document. This is taken with a transmitted light. That means the light passed through the document. The document was placed on the box in which there were lights at the bottom, and the light passed through the document. Now, if you observe these holes, what we call the perforation holes, this stroke has crossed the perforation hole, but the ink has not gone onto the paper on which the revenue stamp is affixed. Similarly, if you observe this point or this stroke, which I beg your pardon, here also you will see the perforation hole is blank. The ink has not gone onto the base paper on which the revenue stamp was affixed. Here, of course, it is a black and white photograph, so you will not be able to distinguish between the different shades of the blue ink, being in black and white. The shade of this stroke was different than rest of the signature. So I gave the opinion that the genuine signature is genuine, but the revenue stamps containing the genuine signature was lifted from another document and affixed to this document. I remember this case for two reasons. One, for the unique forgery in this case, in which I had stated that the genuine revenue stamps containing the genuine signature is lifted from one document and affixed to another document. The cross exam, by the time my examination chief was over, there was about hardly 35-40 minutes left for the lunch break. The judge asked the cross examiner whether he would like to take some break and he continue after the lunch break so that he can cross examine the expert at length. The cross examiner was very honest, very, I should say, well prepared. He said, "Your Honor, I'll take about 20-25 minutes and I'll finish the cross examination before the lunch." The first question he asked me that, "Who had asked you to give the opinion in this matter?" So I said, "I had received documents from the court along with the letter asking for my opinion." The cross examiner was so well prepared. Straightway he took out the photocopy of the office copy of the covering letter which was sent to me by the court. He said, "Is it the same letter which you had received?" I said, "Yes." The document was exhibited. Then the next question he asked me, "Mr. Athale, can you point out exactly in which para the court had asked for your opinion?" As soon as I started answering, the court said, "Well, Mr. Cross-Examiner, there is no dispute regarding this. We can read out or we can find out where it is written." The cross-examiner said, "No, sir, I want specific answer from the witness in which paragraph it is written." Then I read out one sentence in the para in which the court had asked, Hereby you are requested to give the opinion whether the signature on the disputed document exhibits so and so, and the signatures on other documents exhibit so and so, are put by one and are of the same person or not. Then the next question he asked me, "Mr. Athale, please read the sentence very carefully. You were asked to give the opinion whether the disputed signature and the admitted signatures are of one person or not. Who asked you to give the opinion that the revenue stamps are lifted from one document and affixed to another document?" This question was never asked to you by the court. Why did you give this opinion? I said, "Sir, whatever you say is correct. The court had never asked me to give the opinion on this point. But as an expert, I said, whatever I found, I have put forth the facts before the court. If the Honorable Court finds that I have exceeded my limits, my opinion will not be accepted." See, these are the points which we often miss regarding, particularly in revenue, the signatures on the revenue stamps. This is a case, classic example on which the disputed signature was already on the document and which was taken advantage of. This was very early in my practice when, in fact, I was under training with my senior. This was referred to my senior by the income tax department. This was a will which was disputed by the income tax authorities. In this case, this signature, which is marked as D1, was disputed. Again, this signature is genuine signature, but we gave an authentic opinion that the signature was already existing on a document and the matter was written subsequently, taking advantage of the genuine signature on the document, on the blank paper. Again, here I would like you to concentrate on the manner in which the name Dogo Singh Raghu Singh Pardeshi is written. Please look at the letters R, De, Shi. They are carefully written, avoiding this stroke of the signature which was already on the document. If you look to the 3 lines above and even the letters in the previous letters, they are written very carefully, I mean, in a similar uniform size. Only the letters R, De, Shi, they are written in such a way that they are avoiding, or the person has avoided writing across the stroke of the signature. This is what we call the unnaturalness in the writing. And unnaturalness is because the signature was already existing on a document. Whenever the signatures or the documents are like this, or when we observe such findings, we definitely come to a positive conclusion, and there is no other logical explanation for such kind of inconsistency, as we call it, in the writing process. This is again unique case in which the signature of Jivrakhan Singh was taken advantage of. This was written on a blank paper which was taken advantage of. Actually, this was in Khairagad, Madhya Pradesh. Then it was in Madhya Pradesh, now in Chhattisgarh. I had no means of taking the photographs under transmitted light because it was matter in the court. But I could observe that the portion from this, now I am showing you with the help of arrow, that was attached to the document separately, and in order to avoid the attachment or to hide the attachment, the revenue stamps were put in such a way. And in fact, Jivrakhan Singh was supposed to have signed on the revenue stamp because he had received the amount. But the person who prepared the document, he signed on the revenue stamp. Here again, if you observe, this is supposed to be a machine cut edge. Look at the right edge and look at the bottom edge, how irregular it is. By this, I could give the opinion that the signature was genuine signature which was taken advantage of. Now let us switch over to another, again, signature on a blank paper which was taken advantage of. Here also I will tell you few things you will agree. Look at the first 6 lines, 1, 2, 3, 4, 5, 6. The interline spacing in these 6 lines is little wider than the subsequent lines. Similarly, the size of letters, if you observe carefully, you will find the size of these letters is relatively bold than seen in the last line. Particularly last 2 lines, if you observe, the size of letters has gone decreasing. Observing these things, I gave the opinion that the signature was on blank paper and the matter was written subsequent. Even the plea of the defendant was this: I had signed on the blank paper and the matter was written subsequent. Again, intelligent cross-examination by the cross-examiner. After asking some preliminary question, he asked me, well, Mr. Expert, have you examined any other document written by this scribe or by the writer of the document. I said, no, I have not examined any other document written by this person or by the scribe. Next question he put to me was, well, Mr. Expert, you have merely guessed it or just made a wild guess. He gave me a suggestion that this is the normal writing habit of a person. How can you say that the signature was pre-existing? First, whenever a dictation is given to him, he writes with bold letters and distinct spacing. And as he goes on writing, the spacing and the size of letters go on decreasing. Since you do not have the normal writing or you have not examined any other document written by him, how can you say so? Your opinion is biased and so on and so forth. I denied the suggestion. I explained certain things. But after the cross-examination was over, I was discharged. The advocate who had called me, he said, sir, he has a valid point. How we counter it? I say, I gave him the idea. I told him that the only thing is that you have to recall the witness, that is the scribe of the document. And once he comes into the witness box, please ask him to write the same text on blank piece of paper. And I gave him the challenge that if he writes in the same way, I'll stop my practice. I was so confident about my observation. Then he said, then I would like to make application and so on and so forth. I said, that is your lookout, your problem. He moved the application to recall the witness. After much arguments, counter arguments, this witness was recalled. He was asked to write the same text on a blank piece of paper, and he was not shown this document, and the writing was by way of dictation. I'll show you the next slide. Then you come to your own conclusion. I will not explain. You have to come to the own conclusion. Let's see the next slide. See, this is the writing which was written on a blank paper. Here you will observe the uniform spacing of letters from beginning till end. Uniform interline spacing from top to bottom. Now, whenever such opinions or whenever such things are there, there is no question of disbelieving the expert. The court under section 73 also can take notice or take cognizance of such things. And that's why the judgments which I have already cited before our lecture, that expert opinion need not always be corroborated. These are the cases in which the expert opinion need not be corroborated at all. Let us come to again the same thing. This was case referred to me by Karnataka Court in Gulbarga. It is supposed to be written on a chip. This is exhibit P1 on the front side. Look at the manner in which the text is written. Look at the back side. The signature is D1. And look at the manner in which the text is written deliberately to come to the end point or come to the near signature. Again, I'll go back to the previous slide and you will be able to see the difference written by the same person. The manner in which this portion is written and the manner in which this portion is written. This all goes on to prove that the signature was existing on blank paper and the matter and the disadvantage of is taken. This is case of ultraviolet rays examination. Here also, if you observe minutely, you are able to see something between below the words Krishna. This is a case in which a cooperative case was pending before the court, in a cooperative court at Nagpur. The secretary of the society denied the possession letter, that I had not signed his possession letter, and particularly to the Ramakrishna Shravan Sakti. When the document was particularly, now I would request you to concentrate only on the name portion. Here, nothing is much visible, but the same portion, when examined under ultraviolet rays, looks like this. So here, as I told you, I have shown you how important are the different methods of examining the documents. This is again transmitted light help in 138 matter. The date was altered in 2000, or you look at the digit 7. Here it is a mechanical erasure. Blade किंवा अशा sharp instrument ear portion खोडून to bring into the limitation, it was erased and written. Now again I will show you the next portion or the next matter, same 138 matter, same thing here. It is mechanical erasure. 2008 changed to 2009. Again, I remember this case for two things, particularly the cross-examination. After these things, the cross-examiner asked me, Mr. Athale, you have said it is 2008, but my suggestion is the original was 2006. Here is not, it is not the question of whether it was 2006 or 2008. The question is whether there is an alteration in the document or not, particularly the year portion. Here, what we call the importance of the photographs in the signature or the document examination. Here it is not what the expert says. Here it is what you can verify yourself, whether the expert is telling you correct or not. And that's why I said, always say that please cross-examine the expert on the reasons given by him. Reasons are more important than anything else. Putting the question that you have given the opinion on the say of the plaintiff or defendant, normally the experts give the opinion in favor of the person who engages in. No, I never put these questions to any expert, because these are things to be argued. The question or the cross-examination should always be on the reasons given by the expert. And whatever the citations I have already stated or I have already given, that please study on the the opinion given by the expert, particularly the reasons. I'll tell you one thing. Expert witness is the easiest witness to examine in chief and the most difficult to cross-examine, because the cross-examination has to be to the point so that you can argue that the reasons given by the expert are not correct, and hence the opinion based on incorrect reasons cannot be accepted. This is again आपल्या इतिहासामध्ये आपल्याला शिकवलं होतं, आनंदीबाईंनी धचा मा केला. But here in this case, B was changed to K. I beg your pardon, K was changed to B by this method. Again, typewriting. The first I told you, this is how the typewriters can be identified. Look at the word letter O. Son, Sorabji, Dosabhai. In all these places, look at the word O. It looks like reverse C. And this is the original document, because you can see the ribbon markings of the typing ribbon which has come on the document. Look at the word, as I say, letter C, letter O. I'm sorry. It looks like reverse C, mirror image. Now I'll show you another document, that is the codicil, that is attachment to the will. The contention of the parties was that this person was taken to another town. The codicil was typed at another place, and his signatures were obtained by coercion or by force. Our contention was that they are typed on the same typewriter and it was at the same place. Codicil, is a attachment or supplement to the will. Now look at this codicil. It is marked as C for codicil. Here you will see O. It looks like reverse C at all places. This is how we identify the typewriter. This was in Madhya Pradesh, Katni. Now I'll show you another case in which the last line, I have examined this particular case from the photocopy. I also authorizing to sell my share of property situated at Chhindwara. Now, if you observe the letter O, sorry, it is round, golakar in last line, and in this case it is squarish. Here you will find it is squarish, it is round. Look at the interline spacing between these two lines and the above lines. Here it is very close to each other while it is wide. This goes on to prove that after execution of the document, after signing of document, last line, I also authorize him to sell my share of property situated at Chhindwara, that was typed on subsequently on a different typewriter. But unfortunately, now the typewriters are becoming obsolete. And I have a news item in my office which says that the last factory of the typewriter in the world was closed down in Mumbai in 2011. There are no more factories or companies which manufacture the typewriters. These are the important points. Now let us switch over to the fingerprint identification. These are prominent features of fingerprint identification. First is fingerprints are permanent from birth till death. And even after the death, till the skin decomposes, the ridges or the lines on the fingerprint, our fingers, they remain as it is. Equally important is that no two individuals will have identical prints. Even the twins or the triplets, they look similar or identical, but they are distinguished or identified only on the basis of the fingerprints. The authorities or the researchers, after studying the fingerprints, they have come to the conclusion that the chances of having two individuals having identical fingerprints, that stands one in so many cases. I cannot read out the figure, but I know this is much more than what the world population is. Even as you are well aware, in Aadhaar card also, fingerprints are important. And now we have a case or the database for the fingerprints. Earlier we had a difficulty as to how to procure the admitted fingerprints of the deceased person. There were no documents which were executed by the person having the fingerprints. Now we have an authentic fingerprint base of the individuals by way of Aadhaar card. Of course, I'm not sure whether the Aadhaar card, the court will permit to retrieve the data of the Aadhaar card and get the fingerprints from the Aadhaar card authorities. But Aadhaar card is a I should say it's a great advantage as far as the fingerprint experts are concerned. These are the different kinds of fingerprints which you will come across on each of your fingers. The whole of fingerprint science is based only on these four patterns. These are arches, these are sub-classification of arch. These are loop patterns. Here in the top, which I'm showing by way of arrow, it is loop sloping to left. This is loop sloping to right. This is a whirl pattern. याला आपण कमान म्हणू शकतो, याला शंख म्हणतात, याला चक्र म्हणतात. आणि these are the composites, that is mixture of different things. To give the opinion that the two fingerprints are not identical or they are not imprinted from the same finger, one reason is enough for us to say. For example, if the pattern is different, one is loop pattern and then another is arch pattern, we can conclusively say that the two fingerprints are not from the same finger. If we have to prove the identity, I'll show you the next slide how we identify the fingerprint. Here, important point I would like to make it is not the distance between the 2 points, but the number of lines between the 2 points. For example, look at the number of points between point number 7 and point number 8. Similarly, point number 6 and 7, what we call the intervening regions, they are more important. They should be always be exactly the same between the two fingerprints. According to the authorities, even 7 to 8 points are enough to say that the two fingerprints are from the same finger. And as I already stated, one reason that the two fingerprints show different patterns, that is sufficient for us to say that the two fingerprints, they are not from the same finger. Now let us, we are almost coming to the end of the presentation. Let us end on some lighter note. There was one case or one matter of the person in the government department, or I won't name the department, I'll say in the government office. His bill was pending for a long time. The contractor had the discussion with the officer concerned. He said, okay, let us give and take, let us share the profit and all those things. तुम्ही मला मदत करा, मी तुम्हाला मदत करतो. On the oral approval of the contractor, the officer approved his bill by writing like this. Now when the government contractor or the contractor came to know that his bill has been approved, he said, if not today, tomorrow I will receive my amount. Now he cannot do anything. He has to pay the amount. The office has to pay the amount. But officer was smart enough तो काही दिवस थांबला आणि मग त्यांनी त्याच्या अप्रूव्डचं not approved केलं. Again he came to, the contractor came to know that bill has not been approved and the officer has said not approved. तो पुन्हा त्या ऑफिसमध्ये गेला आणि त्यांनी सांगितलं, सर माझी चूक झाली, असं झालं तसं झालं, मला येता नाही आलं, आय एम सॉरी, आय एम रेडी टू फुलफिल माय पार्ट, वॉट एव्हर आय हॅव कमिटेड. The officer said, okay, you do your things first. तर त्यांनी सांगितलं, सर पण तुम्ही ते इथे नॉट अप्रूव्ड लिहिलेलं आहे, व्हॉट कॅन आय, हाऊ विल इट बी पॉसिबल, मला पुन्हा ते ऑल दोज थिंग्स फॉर्मॅलिटीज कराव्या लागतील. द ऑफिसर said, don't worry, that is my headache. You first keep your promise, then I'll do whatever I want to do that. पुन्हा त्यांचं देवाणघेवाण जी झाली, त्याच्यानंतर when he came to know that he has been approved, it was not approved. Anyway, that is the lighter part of the presentation. खूप जास्त टेन्शन नको आपल्याला. I am very much thankful to you for sharing or giving me enough time bearing with me for such a long time. And sincerely thank everybody, particularly Advocate Salgar from Solapur, who gave me an opportunity to talk to you. And believe me, it gives me an immense pleasure to share whatever little knowledge I possess. And I again suggest that, particularly to junior advocates, please cross-examine the expert on the reasons given by him. Please do not cross-examine like any other witness on the say of the defendant, on the say of the plaintiff who has given the opinion, and so on and so forth. Anyways, thank you very much. Thank you for being a part of this lecture. I sincerely thank all the participants for giving me an opportunity and bearing with me for a long time. Thank you. Over to Advocate Salgar.
Thank you so much, sir. There are a few queries. First query is that
yes,
queries by participant. First query is that whether a opinion of expert can be given upon the photocopy of disputed signature or disputed fingerprints on the basis of photocopy. Hello. Hello. हाँ sir. Sir, can opinion expert be given on photocopy of disputed signatures? That has been query asked by the participants. Photocopies, Xerox or
hello.
Hello.
Sir, am
Yes.
I audible? Okay. So I will read out the questions one by one so that you
Right,
can
right,
answer
right,
our
right.
queries. So one of the question that has been asked by Isha
Yes.
Agarwal. So she is asking, sir, can opinion expert be given on the photocopy of disputed signature?
Provided, yes, opinion can be given provided the photocopy is clear and it will be with qualification provider that the opinion given copy is not clear. There is every likelihood there the opinion could be misleading. So the photocopy has to be very clear.
Okay. Okay. One more question from Amit Lohia. He is
Yes.
asking, sir, till what time do the fingerprints remain the same on a dead body?
Sorry?
Till what time do the fingerprints remain the same on a dead body?
Till the skin starts decomposing.
Okay. What is that particular time period, sir? In hours or in minutes? Can you?
No. The decomposition starts after a few days.
Okay.
Sir, one more query is there. Whether the disputed documents can be sent for examination without order of court privately, and such report can be considered by the court during the trial.
Yes, definitely.
Yes.
But if the matter is pending before the court, it is always better that the documents are referred to the expert with the permission of the court. जर का कोर्ट प्रोसिडिंगच्या आधी घेतलेलं असेल ओपिनियन तरी चालतं, but during the pendency it is always better to seek the opinion with the permission of the court.
Okay, sir. One more question from Nilesh Sabnis, and he is asking, what is the procedure to send the handwriting sample to the expert? That, for example, how much specimen signatures of the accused shall be obtained?
Normally, 10 to 12 specimen signatures are enough. Along with the specimen signature, if the document signed in normal course of business, जे नॉर्मल कोर्स मध्ये केलेलं असेल, रुटीन कोर्स मध्ये तेही केलेलं पाठवणं केव्हाही चांगलं.
Okay.
Opinion regarding age of revenue.
Sir, one more question from Sarthak Churi.
Yes.
So he is asking about your opinion regarding the age of a revenue stamp can be given.
Yes, but I'm not the authority to give the opinion. It has to be referred to the Security Printing Press Nasik. They are the authority and their opinion is admissible under 291 of CRPC. I'm not the person to give I'm not authorized or I'm not competent to give the opinion on the revenue stamp as to in which year it was issued.
Okay.
Yes.
One more query is there, sir.
Yes.
So if there are cracks on one's hand, then how one can identify the fingerprint impression?
Fingerprints, as I said, it is on the ridges, and many times the cracks or what we call the white lines, crease lines, they also help us in identifying the fingerprints.
Okay. One more question is that can we identify between the thumb impression of a living person and a dead person, and which is forcefully taken?
Forcefully taken, we cannot identify.
Okay.
As far as the dead person and living person is concerned, theoretically it can be answered, but practically not, because once the rigor mortis is developed, the sweat pores जे असतात ते क्लोज होतात रिजेस वरचे आणि मग ते दिसत नाही. परंतु फिंगरप्रिंट जर का साफ नसेल, क्लिअर म्हणजे काही धूळ माती वगैरे असेल, तर अशा केसेसमध्ये सुद्धा किंवा काही कचरा असेल तर अशा केसेसमध्ये सुद्धा स्वेट पोर्स बंद होतात. There is no scientific method by which we can identify whether the fingerprint is of a dead body or of a living person.
Sir, one more question. This will be the last question, sir.
Okay.
So today on the computer, the line alignment can be adjusted. Then how to consider that the signature not taken on the blank paper?
I had already in the beginning, I told, if it is a handwritten document, then only we can say. But if it is a computer generated document, it is very difficult to identify whether the signature was existing on blank paper or not.
Okay, sir.
Thank you so much, sir. Now I request the Joint Secretary of Solapur Bar Association, Advocate Vaishali Bansoda Madam, to offer a vote of thanks.
Good evening, ladies and gentlemen.